Thank you, and good morning to everyone. You know, it's common to anyone who reads spiritual texts, it's common to see the phrase, we should strive to be human beings rather than human doings. I don't know if any of you have heard that phrase before. The first time I actually heard it was in a song by Scatman Joe. And that may be a dated reference, I'm not sure. You know, if I had a dime for every insight I've heard from Scatman Joe, that's about 10 cents, I think. Anyway, this was a pretty good one, actually, because I think what the gurus had in mind, and presumably what the Scatman has in mind, is we should live life in the moment. We should take time for reflection and meditation, right? We shouldn't spend our lives sort of hustling from task to task or chore to chore. The idea, I think, is that we are defined not by our accomplishments, right? Not by the individual things we do, but we're defined by our core, right? We're defined by our values. We're defined by our constitution, right? In a small c sort of sense. Now, as a law professor and as a constitutional law professor, I think a lot about constitutions. And what I want to spend a little bit of time reflecting on today is the extent to which the Constitution that the gurus and the Scatman Joe, are talking about overlaps with or is perhaps different from the Constitution that I think about and study in my professional life. Now, of course, there are obvious ways in which the Constitution that I study and that I ask my law students to study is different from the small c constitution of the gurus. It's a written document. It's in the National Archives. You know, I'd say that you could go visit it, but as I speak, you actually can't because the federal government is closed. But if the government were open, you could actually go to the National Archives and look at the Constitution, and the document that you see would be a document with 7 articles and 27 amendments. It's a text. It supplies a set of rules that outline the structure, powers, obligations of the American government, give a sense of the rights the American people enjoy. But of course, we all sort of recognize that it's a little bit too simple to think of the Constitution solely in terms of being a written document. And so what I want to do is, in the few minutes that I have, play law professor a little bit with the audience and ask the sorts of questions that I end up asking my law students. And any of you who have been to law school will recognize the sort of form of these kinds of questions. So I'll ask 3 questions. First, could the president direct the Department of Justice to prosecute for federal crimes only people who oppose the president's policies? You might think, well, no, of course not. That would violate the First Amendment. It would violate rights of free speech. But if you go down to the National Archives after the government opens, if you go down to the National Archives and look at the Constitution that's sitting there, you'll look at the First Amendment and you'll see that the First Amendment says Congress shall make no law abridging the freedom of speech. Doesn't say anything about the president. Doesn't say anything about the courts. So could the president violate the First Amendment and violate free speech rights? Could the courts of the United States violate the First Amendment, violate rights of free speech? Right? Staring longer and harder at the document is not going to answer that question. Second question. Is the federal government bound by the equality guarantees of the 14th Amendment? So could the federal government, for example, and going back to a World War II theme, could the federal government decide to detain Japanese Americans during World War II solely because of their ancestry, which of course the federal government did? Would that violate the Equal Protection Clause? Well, If you look at the 14th Amendment, it says, no state shall deny to any person within its jurisdiction the equal protection of the laws. It doesn't say anything about the federal government's obligations towards its citizens. So is the federal government not bound by equality guarantees? Korematsu versus United States, the Supreme Court decision from 1944 that sanctioned that practice of detaining Japanese Americans, that has to be wrong, right? It must be wrong, mustn't it? Third question. Did we pass an Equal Rights Amendment? The ERA was supported by overwhelming majorities of Congress, both houses. It was supported by President Nixon, of all people. It passed, it was ratified by 35 states, but not 38. And if you look at the Constitution that sits in the National Archives, you would need 38 states to ratify the Equal Rights Amendment. But virtually everything the Equal Rights Amendment would have accomplished, and maybe even literally everything the Equal Rights Amendment would have accomplished has been accomplished anyway, either through Supreme Court case law or through laws and regulations that have been passed by governments. No lawyer, no competent lawyer, would say that the Constitution doesn't give any special protections to sex discrimination. So what's going on, right? We are a nation in which the president must respect free speech. We are a nation in which the federal government is bound by the guarantees of equality in the 14th Amendment. We are a nation in which women have equal rights under the law. And not just that, but when we think about those guarantees, we think of them as constitutional guarantees, right? These are not just customs or legal conventions or things we happen to do. These are in the Constitution. So how did all these things happen? Now, applying rights like free speech to the actions of the president and the president's administration, absolutely essential in the age of the administrative state in which lots and lots of the rules and regulations that govern even private conduct are generated by administrative agencies that are controlled by the president. Free speech became an essential part of our identity as a nation, not because it's written into the First Amendment, but because of many, many, many decades of struggle by people who were burdened by, attacked by, targeted by exactly the kind of hypothetical laws that I mentioned in my first question. The notion that the federal government is bound by the Equal Protection Clause, first authoritatively announced in a case called Bowling versus Sharp, companion case to Brown versus Board of Education, in which the Supreme Court said that Congress could not racially segregate the schools of the District of Columbia. Now, in that case, the court said, it is unthinkable that the guarantees of equality that apply to the states would not also apply to the federal government. How does a right go from not in the Constitution to having its absence be unthinkable? Well, in the context of segregated schools, in the context of applying equality guarantees to the federal government, this happens because of a social movement and a litigation campaign led by people like Thurgood Marshall, people like Charles Hamilton Houston, who worked really hard, including with allies in the federal government, in the Department of Justice, in the State Department, to make sure that those equality guarantees were written into the Constitution. And in that context, in the context in which they're not just reinterpreting the Equal Protection Clause, they are elaborating the conditions of justice. In that context, it is indeed unthinkable that we would distinguish between a state and the federal government as discriminators. What about the Equal Rights Amendment? The women's rights movement responsible for drafting and promoting the Equal Rights Amendment didn't just pack up and go home when ratification stalled and eventually failed. right? They continued to influence public opinion, which filtered its way to state and local actors, which filtered its way to Congress, which filtered its way to the federal judiciary, and state judges as well. The Constitution changed in that context because we changed. We changed as a people. The American people changed. So, along one dimension, right, the dimension of unwrittenness, the distinction between the individual small c constitution of the gurus and the big C constitution that I study and talk about with my students may not be that great. The Constitution is a thick description of the values that constitute us as an us. Now, you might say, well, there's still some complexity, right, in thinking about a constitution, a small c constitution, in a collective sense rather than an individual sense. Am I really part of the same we the people as someone 3,000 miles away, as someone with very different background, very different history, very different set of individual values, very different individual constitution? Am I part of the same we the people that battled segregation, that helped get equality rights for women written into the Constitution? Am I part of the same we the people that was responsible for sanctioning slavery as something protected by the Constitution for 77 years? Well, these are hard questions, but we might think about what the alternative is, right? If we are not part of the collective that shapes constitutional meaning and has done so for a long time, if we're not part of that we the people, then it is difficult to understand why it has any authority over us. It's difficult to understand what the source of its authority is. We are complex people. We're social animals. We have multiple identities. Part of that identity is a national identity. We are all, in some sense, authors of an ongoing autobiography of America, right? Its Constitution is our Constitution, at least in part. But here is where, finally, I'm going to part ways with Scatman Joe and with the gurus. Because however we live our lives as individuals, it is important for us to strive to be a people doing, right? Not a people being, not a people acted upon, but people who are actors. The Constitution has changed to be much closer to the people we are today than it was 200 years ago, 226 years ago. Because people have acted, right? Because people have had agency, because people have taken responsibility for making the Constitution theirs and to making it our own. Right? To paraphrase a constitutional scholar, Akil Amar, the Constitution is not just a text, but a deed. It is a doing. It is a constituting. It constituted us as a people, and it continues to be a constituting. The theme of this conference is the care of the future is mine. Well, the care of the Constitution is thankfully not the federal government's. The care of the Constitution is ours. Thank you.